Let's start again for this last leg of the marathon. So what we will do now is to discuss the two other papers. So this was a kind of quadrilogy, if you want. We discussed already the first two papers, which were more, in a way, on substance. And now we move more on governance and institution, which are as important as substance to have an effective and proportionate implementation. So first we will start by a paper by Zach Meyers, who is already on the website, on governance, and then there is I will present the paper Giorgio Monti and I wrote. So Giorgio is ill, and so I have to step in for him, but he really did a lot of work, and which will answer some of the consideration that were mentioned by Bartek before on this relationship between the DMA and other law. And then we will have the panel, and in the same way as we had previously. So to save time, I will not introduce everyone. You have the program and they will be also shown there. But as always, I mean, we wanted to have a different interest, corporate, regulation, and civil society represented. So that's for the first hours, and then the second hour will be what everyone, I guess, expects, is this discussion between Margaret Vestager and Bruno Libabert. Okay, so Zach, you have the floor.
Thanks, Alex. So EU policymakers are increasingly viewing platform openness as a central tool for strengthening competition, as well as kind of resilience and innovation in digital markets. And we're going to publish a paper with a fellow academic at CERRE, Kamel Senamo, which is going to test this assumption and explain how we should design rules to mandate openness in ways that deliver maximum innovation. But in this paper, I'm looking specifically at the rules in the DMA, and it's focused on a much more practical question. And this is, given that the DMA's rules do mandate more openness, how can those obligations be implemented in a way that is most effective and proportionate? And there are three types of openness that I'm looking at in this paper. The first is portability, which was discussed to some degree already, but this is the idea that users should be able to either download data and then upload it to a competing service, or ask a gatekeeper service to move the consumer's data directly to a competitor. And the idea is to make it easier for consumers to try different products and easily bring their data with them. I'm also talking about horizontal interoperability, the topic of Jan's paper, which is primarily so that messaging services today can choose to allow their users to communicate to or from a regulated gatekeeper service like WhatsApp. And then it talks about vertical interoperability. And this is the ability for third parties like app developers or those who are producing kind of smartwatches or similar types of devices to access all of the functions of a gatekeeper's operating system, which the gatekeeper uses for its own products and services. And the purpose here is to make sure that third parties can build products and services that are just as useful and just as competitive as those that the gatekeepers are able to do. So really what these elements of openness are trying to do is to open up choices in a technical way so that third parties can get access to whether it's a user's data or gatekeeper assets, where they're going to need this to be viable. So the DMA sets out some high-level obligations relating to openness, and it's largely silent on the technical, on the commercial, and on the governance mechanisms that are required to make portability and interoperability work in practice. And the paper looks at kind of these types of problems, and it identifies that there is quite a few different sub-questions that have to be resolved before any of those types of openness can be workable in practice. Examples of these are answering the questions of which data or which functions have to be made open for third parties to be able to use, how those data or functions should be defined. So for example, what format should they be in? Should that format be something that is useful for the gatekeeper or useful for the third party? Should these be provided using APIs, through open protocols, or through other type of technical systems? What features should the interfaces that third parties use to get access to the data or functions have so that they are most useful? What quality standards should openness meet? So for example, if you are trying to port your data, should that be able to happen instantaneously? And then how do we ensure that security and safety are protected while making platforms more open? And this is quite important because security really does matter. In competitive markets, we know that products are quite rarely completely open. Usually they fall somewhere in a spectrum between open and closed. And this is because issues like security do matter so that people have trust in the platform service. That's reasonable, but what we need to do is to make sure that those safety mechanisms aren't applied in a way that undermines the effectiveness of what the DMA is trying to do. And look, we know that all of these questions have to be answered before the products, before openness services can actually work in practice. We've seen this in other sectors where we've tried to make products and networks open, like in telecommunications. And what we know is that these questions also involve trade-offs. So to give some examples here, we know that app developers want certainty. They want these technical solutions to be stable so that they can invest money in apps and services that feed off them and can rely on them. But at the same time, the gatekeepers will want flexibility to allow their services to evolve, and sometimes evolve in ways that might mean that the technical solutions and the third parties that rely on those technical solutions have to kind of invest more or update their systems. As I said, the quality of these facilities matters, so users are not going to trust horizontal interoperability, for example, unless it is really easy to use and that it always works. But the higher the quality standards you insist on, the more expensive compliance becomes, which can kind of shift the balance between benefit and cost. And some of these questions, as we discussed in the previous panels, involve trade-offs between different types of business users. So we shouldn't just assume that this is a gatekeeper versus business user dichotomy. So for example, different app developers might all want their own apps or services to get priority access to the memory or the processing power on a smartphone, but of course, like, not every app developer can have that priority, or no one does. And of course, large app developers might be more willing to accept and meet stringent security standards that gatekeepers might try to impose, whereas that might impose more of a barrier to smaller app developers. And so this poses a question, which is, how are these decisions going to be made in ways that deliver fair, effective outcomes? And given the volume of discretionary decisions that are involved, the point of this paper is to show that governance mechanisms, which is the processes by which we make decisions about implementing openness, play a critical role, and that my suggestion is that they haven't received enough attention yet when we're thinking about DMA implementation. So the paper sets out 3 different options for governance under the DMA, which are not mutually exclusive by any means, but maybe 3 different avenues by which governance can be made. The first is the one that is kind of the default in the DMA, which is a gatekeeper-led approach. And this involves gatekeepers proposing their own compliance solutions, with the Commission providing a degree of oversight and then intervening only by exception, so where it objects to what the gatekeeper is doing. And this is kind of understandable as kind of the first round of getting the DMA to work here, because gatekeepers understand their own systems and platforms the best, and so it is the simplest and the easiest way. But clearly it runs the risk that we undervalue what is important to business users and makes the DMA less effective than it could otherwise be. The second approach has been adopted in a few places now, where the Commission either has or is proposing to actively specify how the gatekeepers should comply with the DMA. And this is an important addition to solve some of the problems that have appeared in aspects of the gatekeeper-led approach, but it also suffers some problems as well, I'm going to suggest. And one of these problems is that under the DMA, the Commission has to intervene on very complex issues in very short timeframes. And it's very difficult for the Commission, under those constraints, to run a very careful process with the sorts of things that you would expect, like open consultation and trade-offs being very carefully considered and openly considered. And this complexity also means the Commission can only intervene in very targeted ways, despite the number of implementation issues that we would like to see the Commission addressing. And so that leads me to this third option, which is a more inclusive governance approach. And this means introducing mechanisms for more collective, transparent, and inclusive governance, such as having structured dialogue between gatekeepers, business users, regulators, and public authorities. The idea of these inclusive governance mechanisms would be to require decision-making about openness to be made in a more transparent way, to promote more balanced decision-making, and to make platforms more accountable for the decisions that they do make, and to show, for example, how they are valuing and weighing different interests of different stakeholders. Inclusive governance raises challenges. For example, depending on how it is designed, it can be slow, which is why this paper doesn't recommend moving straight to a highly institutionalized standardization process. But what we've seen in other regulated sectors, like telecommunications or energy, is that it can help significantly in making rules more effective, and where it can solve problems, it reduces the number of times that the Commission will then need to intervene in very specific and time-limited ways. So in practice, what this means is steps towards more inclusive governance could include requiring gatekeepers to defer to the judgments of third-party intermediaries, such as the Data Transfer Initiative or trust registries, entities which are kind of trying to build trust across different gatekeepers and involving business users with them, the types of institutions that might be more likely to make decisions that balance the interests of all stakeholders fairly. Now, no single governance model is appropriate for every DMA obligation or even for every type of platform service. But in general, the purpose of this paper is to highlight that it makes sense for the Commission to pay more attention to the benefits of requiring gatekeepers to engage in more transparent, inclusive, and institutionalized governance processes. And over time, we think that these mechanisms could provide a more credible basis for third parties to invest and innovate, where we have seen that the levels of investment in innovation have been suboptimal so far. Thank you.
Because of course those governance issues are absolutely key, and so that's why we want to spend time on them. So the last paper of the series is on the regulatory interplay. I mean, and so basically, I think everyone is for regulatory consistency. You know? I don't know if some people are against, but I mean, maybe some lawyers, some in-house lawyers, but I guess most of the people will be for. And it's interesting to see that in the communication that the Commission adopted last year on the DSA and other law, it's really a good read. I really recommend everyone to read that. But I mean, clearly, one of the main messages that the Commission is giving there is we need more clarity, coherence, and coordination in the different laws. Okay. Now, of course, the DMA has a relationship with a number of laws, some horizontal ones, some more specific to digital. So there is an obvious relationship with competition law because the DMA has its, in a way, sources into competition law cases, to privacy, in particular the GDPR, to security, in particular the NIS2 directive and the Cybersecurity Act, which were mentioned. So we have dealt with those issues in the report last year, and so we come back to the issue of the GDPR this year because this is really a live issue, and there has been those joint guidelines I will mention in a minute. But also there are some interesting relationship with the DSA and with IP law that we touch a little bit in this year report. So now the question is how to achieve more consistency, and I would say there are at least three ways. You know, one is to go through soft law, through guidelines, and so that's why we are really positive about these draft joint guidelines that the European Commission and the EDPB have adopted on the relationship between the DMA and the GDPR. But what is important then for those guidelines is that they are adopted in a transparent and with a participatory process. So that's why we think it's good that there was a public consultation on those guidelines, and there will be also a meeting with the EDPB at mid-March where those guidelines will be discussed. We also think that those guidelines should give clear indication. They should be indeed guidelines and not, you know, the least common denominator between DG Just, DG Connect, DG Comp, the EDPB, and you name it. So of course we know that it's not easy to negotiate among different stakeholder or regulatory actors, but it's very important that they deliver a clear message at the end. The second one is to go through legislation. So either we go through a digital omnibus, and we were discussing that with Kai this morning, And I would say that, for me, what is missing a little bit in the digital omnibus so far is that they don't really touch about the regulatory cooperation. And I think that, you know, we can work, and I don't think it requires a full reform, on improving the legal ability and the incentive for the regulator to cooperate more, you know, and for instance, to have the possibility to exchange confidential information. Then, of course, there is the more ambitious exercise that the Commission has started, the digital fitness check, where maybe, you know, the end game of all of that would be a digital code. You know, in the continental Europe, we were very fond of the Code Napoleon, and they last for more than 2 centuries. It would be nice to see an act of the Commission, of the Parliament and the Council lasting for more than 2 centuries. So that's the second avenue. And then the third avenue is, of course, but we discussed that this morning with John, and I will come back very briefly at the end, to have more cooperation within the regulator, and to have, in the context of those governance mechanisms that Zach was mentioning, they can also be a way to discuss interplay between the law. Now, 2 words on the draft joint guidelines on the relationship between the DMA and the GDPR. What we think is that 3, let's say, horizontal points are important for us and sometimes could be made clearer in the guidelines. The first is that we need governance mechanism, and to come back to what Zach was saying, to allow this dialogue between gatekeeper and business user. For instance, you know, data portability or portability of data in general. I mean, this is requiring, you know, good interface, good dialogue between the business user and the gatekeeper. And I think more governance mechanism and more indication in the guidelines on what kind of governance mechanism are needed would be very useful. The second thing is the importance of choice architecture. I mean, we know that it's key in determining the choice of all of us, and it's very important that you know, the information on the different choice architecture that can be tested and tried by the gatekeeper are sent to the regulator, so they know that this choice architecture will lead to that choice, this other choice architecture will lead to this other kind of choice. So I think this is very important, and again, we would claim that maybe even more importance should be given to them. And finally, and this is maybe a little bit more controversial, but maybe the guidelines could contain some safe harbor, in the sense that saying, okay, if you follow the guidelines, then it means that you comply, you know, and then you are safe in terms of your compliance. Because too often we say the guidelines say you could do this or you could do that, but the legal consequence of following the guidelines are not clear enough to us. And then finally, and that's the last slide, it's about the enforcement challenges. On public enforcement, we discussed that this morning. The digital clearinghouse is probably a good way to go, but maybe on the longer term, you know, we should break up the Commission. And let me be clear on that. Breaking up the Commission means that there is a number of functions now that the Commission has, and some of them are in conflict, you know, being the geopolitical government of Europe and at the same time being a regulator which is under a huge pressure of the Trump administration today. Maybe it's too much, you know, it's a conflict of interest which is too high, and maybe we should move towards an EU digital enforcement agency. I mean, you may have seen that the Parliament now is coming back to this old idea of having an independent antitrust authority. And it's interesting because it's an idea which came back, you know, when the treaty was negotiated from the Germans, and then when the merger regulation was adopted in the 90s, there was another discussion whether DG COM should go out and be an independent authority. And it's interesting that Jon Courtin and others at the Parliament are pushing that idea today. It will be interesting to hear the view of Margrethe Vestager on that later, maybe. And finally, in terms of private enforcement is absolutely key because it's a way to complement and accelerate the enforcement. So we think that private enforcement is absolutely important, but it requires good cooperation between the European Commission and the court, and the national court, because those are complex matters. And I mean, the good thing is that the DMA provide a possibility for the European Commission to go before national court, but we think that is also very important. So those are the main ideas that we present in the report, which is published on the CERRE website.